topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good evening. Welcome to another Ask the Expert show. We are so excited because this is the first Thursday of the month, which means we have the K. Bender Rimbaum show, and we have board certified attorney Robert K. as senior partner. If you have a question tonight, there's several ways that we can ask Robert our questions. First one, you can call us here at 561-623-9429. That's 561-623-9429. This is our community association law. So if you are a board member, you are a management company, or you live at a Condo HOA Association and you have a question tonight, give us a call. Or we've been stocking up all your tweets and your letters, your emails to us, and then we will ask those to Robert this evening if we get to them all. The number, if you'd like to send us a message, it's 954-336-3767. And we also have our chat board right to the right. And let's welcome attorney Robert K. Good evening, Robert.
Hello, Steve. Hello, everybody.
Good to see you.
Thank you.
People seem to really like the way that you answer questions. So I guess we'll probably have to do this for another 5 or 6 years.
Hopefully.
Anyway, but I got to tell you, we're getting so many new people, a lot of board members, a lot of officers. So let's do this. Let's tell everybody about K. Bender Rimbaum again for all the new people out there.
Well, K. Bender Rimbaum is a full-service law firm that focuses its efforts on community association law, condominiums, homeowner association, cooperatives, out of our offices in Pompano Beach, Palm Beach Gardens, Orlando, and Tampa. We provide legal advice and assistance on all aspects of community association issues that boards of directors are faced with on a daily basis. Collection of unpaid assessments, addressing limitations in covenants, covenant enforcement issues, negotiation of contracts with third-party vendors, dealing with construction defects, complex litigation issues that come up. Dealing with local governments, zoning boards, anything an association will face on a day-to-day basis from a legal perspective are the things that we focus on. We have a large number of our association attorneys are board certified by the Florida Bar in this area of the law, which there's only about 200 in the state of Florida, and we have about 10 of them. And we have a board certified construction defect attorney as well.
Well, I got to tell you, you are one of the top community association law firms in the state of Florida. And we're going to get right to the questions. If you look below, you've got a lot of classes coming up. We're going to be broadcasting those during the entire show tonight. And
we'll talk about them too.
Yeah, because we do have the radio people. So let's get started with our questions. And we're going to go to Kelly first. Boca Raton, if a condo board updates changes a rule or regulations for the happiness of the residents, and it's a different from the bylaws, is it legal to do since our docks are 20 years old?
Well, that's an interesting perspective on the issue. For condominium associations, you have multiple levels of documents that you're dealing with. You have your declaration of condominium, which is the use restrictions on the real property. You have your articles of incorporation, which sets up the association with the state of Florida, and the bylaws, which are basically the operational manual for how the corporation works. And then under all of that are rules and regulations, which are typically authorized to be adopted by the board of directors and usually don't require a vote of the owners. If your condominium was from the late 70s and you never amended this, some of those documents do require unit owner approval of rules. But for the most part, the vast majority of condominium associations, board has the authority to adopt rules. Now, Florida law creates an analysis that we go through as to whether or not a rule adopted by the board is going to be enforceable or not. And the first requirement is that the board have the authority to adopt the rule in the first place in the governing document. So we have to look for that. Assuming that they do, the second level issue is the one that's most critical, and that is whether or not the rule is in conflict with what's in your governing document, the declaration, articles, or bylaws, either what's expressly stated there or inferred. And the inference part is important because if the documents are silent on something, then the inference is that it's unrestricted. So if, let's say, there's nothing in the documents about restricting of trucks, and the board adopts a rule, says no pickup trucks allowed in the community, you have a conflict with what's inferred from the documents, the unrestricted truck parking. So you have to look at those things. And the last item that the rule will have to be is reasonable on its face and in its application. And while we can't make the final determination of whether it's reasonable or not as the attorneys, we can give you our best professional judgment on it. Ultimately, if it comes to a legal challenge, it's up to the court if it's reasonable. But, clearly certain things are going to be more obvious that they're not reasonable than others. So it's going to be something you have to look at on a case-by-case basis.
This next question we've actually had about a month or two ago. This is from Bill and Davey. What is the difference between material alterations and architecture change?
Well, they're similar and different. Material alterations in condominium is a significant item because the statute refers to material alterations and substantial improvements to the common elements and provides there shall be none except as provided in the governing documents. And if the documents are silent, then upon the approval of 75% of the owners. The courts have done analysis through the years, interpretation as to what constitutes a material alteration. And most anything that changes something that's already there or creates something that wasn't there before would be considered a material alteration. Now, architectural change probably falls within the umbrella of a material alteration. And so architectural change is not a term of art in the law, but it's in its everyday usage. It means you've changed something on your building. So in all likelihood, that's going to be a material alteration. Now, whether or not that's going to require a unit owner vote, first you got to check your documents. Then you have to look at what the specific alteration that you're making is. Is it necessary maintenance as required under your declaration, or is it more of an improvement from something that was there? If it's necessary maintenance, even if there's approval language required in your documents, the board can do that on its own based on longstanding case law in the state of Florida. So this is something that you're going to want to get with association counsel on before you make your ultimate decision as to whether or not you need a vote of the owners. and do the analysis on an item-by-item basis.
You know, Robert, we get a lot of people writing, and I try to break it down into one, maybe two, but a lot of people wanting to know about borrowing funds from another reserve account to fund another reserve account. So here's Kathy in Boynton Beach. Do you ever recommend borrowing funds from another reserve account to fund another reserve account projects like roof funds or dock projects?
Well, reserve funds are a little different in condominiums than they are in HOAs. So we'll talk about condominiums first. And in condominiums, you have certain specific items in reserves that the statute make mandatory, which are the roof, the painting, the paving, and any item of deferred maintenance over $10,000, which can be a number of things, depending on what you've got to deal with in the property. The law also says that reserves being held can only be used for the purpose that they have been identified as, unless used for a different purpose is voted on by currently a majority of the unit owners at a meeting at which a quorum has been attained. There's a change in the statute coming that's going to change that to a majority of all owners, assuming that the governor signs that change, which was just adopted very recently by the legislature. But in any event, the taking of reserves for the roof and using it for the parking lot is not allowed under the law unless you have a vote of the owners. The way some associations get around that is by using a method called pooling of reserves, in which all of your reserves are put into a single big account, and then the money is used for the various purposes. But technically, it's a complex accounting aspect to the manner of dealing with reserves. You're not supposed to use more funds than you would need for a specific item, and then you'd have to be replenishing. It's something you're going to need your accountant on if you're going to do that. But if you're going with a straight line reserve method where you're reserving for specific items, you're not allowed to borrow from those reserves to use for any other purpose than what they're being held for, unless you get a vote of the owners. Now, for HOAs, reserves are often misunderstood. There was a change in the statute about 10, 11, maybe 12 years ago, in which it created a reserve procedure that required the owners to basically adopt reserves if the developer didn't provide for them originally in their documents. And the documents that were in existence before the statute, any reserves created there weren't contemplated by the statute and don't count. So many communities have items in their budget that they call reserves in HOAs, but they're really not the statutorily protected reserves. So if you don't qualify for what the statute limits and the use, as having never had a vote of the owners to adopt these types of reserves in the first place, then you have a little more latitude in what you can do with them. You're able to reallocate them, use them for other purposes, or not even use them for reserves at all, unless they're the statutorily protected kind. And for HOAs, you're going to want to get with your attorney to make sure whether or not you have the statutorily limited ones, or if you have the type that you can be a little bit more liberal in their use.
Okay. Phone number here, if you have a question for Robert, is 561-623-9429. Let's go over this month's schedule, Robert.
Okay. This month we have a number of items of interest to everybody. There's only one live event. The rest are, we have two live events, I'm sorry, and then 3 Zooms. On Wednesday, May the 10th at 7:30 a.m. is a live event, 7:30 to 10 a.m. Legislative session update live at Galuppi's in Pompano Beach. Lisa McGill from our office here in Pompano Beach will be presenting. It's hosted by ACE by TSK. There will be a hot breakfast served, so that one could be interesting. And there are some CE credits that are available there as well. On Wednesday, May 17th on Zoom, 2 p.m. to 4 p.m. is an HOA and Condominium Association board member certification class. It's a double one. It'll cover all of it. Alan Schwartzide from our Orlando office will be presenting, and that's at 2 o'clock to 4 o'clock on May the 17th. Then on May the 23rd, Tuesday, conflicts of interest, what you need to know. Zoom from 11:30 a.m. to 12:30 p.m. That one will be presented by Alan Schwartzide again from our Orlando office. There is some continuing education in that one, credits for CAMs. And then on Thursday, May the 25th, Navigating the Federal Fair Housing Act, Assistance Animal or Pet, a Zoom session from 11:30 to 11:30 a.m., 12:30 p.m. Danielle Brennan from our Palm Beach Gardens office will be presenting, and there is some CEUs available for that. And then the last item for May, on Tuesday, May the 30th, from 12 o'clock to 3 o'clock, live in our Orlando office with Alan Schwartzide, HOA and Condominium Association board member certification class, a live one with continuing education credits. Now, the live one there has very limited seating opportunities, so it's important to be sure to RSVP and secure your spot. And if you do RSVP that you're coming, please do come. All of these are found on our website, kbrlegal.com, in the calendar. Go to the event that you're interested in, click on it to reserve your spots. You can get your Zoom credentials or secure your place in the live ones.
What if they need to contact your office, Robert?
You can contact our office at 800-974-0680, or you can send an email to info@kbrlegal.com. Or you can go to our website, kbrlegal.com. There's a contact box on the homepage. Fill that information out, and then that will get to us, and we'll get back to you fairly quickly.
Great articles on there, too. It's well worth going to the website. We're going to go to break now, and we come back. We have more of your questions with Robert K., attorney board certified Robert K. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show. This is the first Thursday of the month, so that means the K. Bender Rembaum Community Association Law. And for some reason, my comment didn't show up. Now it is, and we've got all kind of comments on here. So let's get to your comments. I apologize for it, but hey, we found it now. let's go to Bruce. Wants to know, can an HOA architectural review board make a motion that applications for a certain modification can be approved without public hearings by the president?
Can an HOA architectural review board make a motion that applications for certain modifications approved without a public hearing by the president? I'm not sure I'm following the question. Who's doing the public hearing? The board or the president? Who's making the motion? The board generally sets up criteria for how the architectural review board will handle these types of applications. And the architectural review board is typically limited to what it can do relative to procedures within that particular community's operations. And quite often that's laid out in the Declaration of Covenants for the community. If it isn't, that raises other issues, a potential problem for that association as well. So it's conceivable, yes, that is something that could happen in this community, but without seeing the documents and getting more details, it'd be hard to say for sure.
Okay, this is from Howard. How does condo HOA different from an HOA that has homeowners instead of condos?
How does condo HOA differ? Well, a condo would be a condominium association. HOA would be a homeowner association. They're different in the way they're created by the statute. A condominium, it only exists because of the statute that identifies condominium methods in Chapter 718 of Florida statutes. Homeowner associations existed before there was a statute, which started in 617 and then moved to 720 some years back, and initially was set up more for procedural aspects of association operation rather than specific use restrictions. It's evolved over the years and tried to get more similar to the condominium legislation, but there are legal issues involved that are different in HOAs than they are in condos. That could take quite a bit of in-depth discussion that might go a little beyond the scope of this particular show. But there are different laws for the different types of communities, and so you'd only apply those laws to whatever you've got.
Okay, next one is from, well, we have a lot of people asking questions. By the way, if we've had a couple people ask us how to ask you questions besides, I guess, just right here on the board. 561-623-9429. That's 561-623-9429. 561-623-9429. All the people are asking how else they can ask questions. We've got a ton right now. Let's go back. Pablo, Condo 718 board obtained a $1.5 million line of credit 15 months ago. Since then, they sometimes get advances from bank and issue work orders before project is voted on open board meetings. Is that legit?
Well, as described, it sounds like maybe not. In order to get a $1.5 million line of credit for projects at a condominium, typically the bank is going to require specifics as to what that is going to be used for and a special assessment against the members to use as the source of recovery on the loan. And there should have been board meetings that went on in advance of all of that, at which this was all discussed and voted upon. And if none of that happened, then there is cause for concern. If the board is just going off without following proper procedures relative to adopting special assessments and entering into large construction projects, that is a problem the membership is going to want to address. You need to attend board meetings and discuss with the board. You can make a written inquiry by certified mail to get answers to specific questions. And if you get the runaround, then you may need to go to the Division of Condominiums and file a complaint for them to investigate if the board might be using funds in an inappropriate fashion.
Okay, let's go to Doug. Ignoring our condo association's governing documents, what methods do Florida statutes provide for condo board members to reach decisions and direct its property manager to act between board members?
Well, first off, I don't think it's wise to ignore your governing documents, but that's not the question you're posing. The statute says that the boards can take action at a meeting that is posted in advance and open for participation by unit owners on agenda items. And there's also an entitlement under the statute for the board to take action by written resolution that's signed by 100% of the board members, in which case there would be no meeting and no discussion. And it's not a suggestion that that's the best method of operating, but it is a legal method that's available for the board to take action. Oftentimes there are issues that boards have to address in between board meetings, and they're allowed to communicate with each other by email to get an idea of how each are leaning toward on specific items. That there are things that might not be able to wait for the meeting, at which point at the meeting the board members should be ratifying decisions made in between meetings and addressing things to clean up any dangling issues that may exist.
Okay, let's go to Barbara in Boca Raton. What can owners do if their property management company is not responding or acting upon complaints regarding non-compliance with association governing documents?
Well, that one's a little more difficult for owners to deal with. Attending board meetings and asking questions is one of the best methods, and having an open dialogue with the board where the board is actually operating in that fashion and being responsive. For condominiums, the law allows you to submit written inquiries and receive substantive responses within a certain period of time from the board or its attorneys, which is a method. And if the non-responsiveness continues, the only avenues available would be to hire your own attorney to address. And in some instances in condominiums, the Division of Condominiums might be an option to address certain complaints that fall within their jurisdiction. So those are the main methods of addressing that type of situation.
Okay. We had a question before. Someone's writing back that, for clarity, the question I had is in regards to the new milestone inspection law for condos. I guess that was, let's see his up there. Can a digital model with a high resolution imagery inspected by an engineer be used as a visual inspection?
I don't believe that's the case, but I can't tell you 100%. There is some changes in the legislation that's coming through, waiting for the governor's signature that may address that. But my recollection is that an actual visual inspection is what's required, not a digital representation.
Okay. You know what? I also want to go back to you've got your classes coming up. Do that for the second half hour now, if you don't mind.
I don't mind. Wednesday, May the 10th at 7:30 a.m. till 10 a.m. live at Galuppi's in Pompano Beach. Legislative session update by Lisa McGill from our Pompano office. That's an in-person gathering. On Zoom on May the 17th from 2 to 4 p.m. HOA and Condominium Association Board Member Certification course is going to be presented by Alan Schwartzide in our Orlando office. On Tuesday, May 23rd, conflicts of interest, what you need to know, from 11:30 to 12:30, also on Zoom, and Alan Schwartzide will be presenting that as well. On Thursday, May 25th, from 11:30 to 12:30, Navigating the Federal Fair Housing Act, Animal or Pet, Danielle Brennan from our Palm Beach Gardens office will be presenting. And then on Tuesday, May the 30th, we'll have a live presentation in the Orlando office from 12 to 3 p.m. HOA and Condominium Association Board Member Certification course. On the live Orlando one, it's limited space, so if you want to attend that, it's important that you secure your spot in the RSVP. Go to our website, kbenderembaum.com. Click on the calendar for and you can see which item interests you, and click on that to RSVP and secure your spot.
Okay. Let's go back to our questions. Let's go to Frank in Fort Lauderdale. Board does not hold vendor accountable for contract. One homeowner owns a landscaping company that services our community, but only provides half of the contracted services. Any recourse against the board of directors?
If the board is aware of and complicit with something that's improperly using association funds and not receiving the services you're paying for and allowing that to continue, if there's a conflict of interest among the party, the board members or officers and the vendor, these are items that would constitute a breach of the fiduciary duty of the individual board members to the association. There would be legal recourse through court action. If the board is improperly using association funds, the division of condominium could be brought in, which would be more cost effective to the unit owner to do an investigation and see if that is a method of resolving that type of dispute. It's either that or a private attorney for the individual unit owners to address with the board.
Okay. Shirley in Pompano Beach wants to know, what does the board have to do to bring on new property management company for the first time? We are a condo association with 80 units.
Well, there's no real special procedure that's required to engage the services of a property manager, no different than any other vendor. The board would have to meet and make a determination to enter into that contract. It's advisable to have the association attorney review any contract before the board signs it and negotiate as necessary with the proposed vendor. And then once the property manager has been hired by the association, then it's a matter of communication with all the unit owners as to the changes that have been made, where they're to communicate, what the property manager's function is going to be within the community operation. It's not necessarily the same in every community, so the board will be making decisions as to that.
Okay. Let's go to Jerry in Deerfield. They are a condo association. It's been 3 months since we have seen financials from our management company. What can we do?
Well, I'm not real sure as to the question if financials are something that they would expect to receive more frequently. Are we talking about the regular operating financials on a month-to-month basis, or are we talking about the financial report that's due at the end of each year? An inspection of the association records is one option if you're talking about the more general financial records on a month-to-month basis. If you think that there's an issue going on with the finances of the association, that's the time to bring the Division of Condominiums Enforcement Section into the situation, because that's certainly one of their jurisdictional items that they get involved with quite frequently. And they'll get more responsiveness from the association than an individual unit owner might. You have the option to make a written inquiry about specific issues, and then the board has the obligation to respond. And if they don't, there are penalties relative to the ability of the board to recover attorney's fees if there's litigation on the issue. And then lastly would be to engage your own individual attorney to address the situation directly with the association.
Okay, Craig in Delray Beach, does a condominium board meeting with the attorney need to be noticed to the membership?
Well, technically, every meeting of the board needs to be noticed to the membership. And based on the question, I'm going to guess that this particular meeting is one that is to address issues that the statute allows to be closed and not open to unit owner participation. Just because a meeting is closed does not negate the requirement of notice and even keeping minutes. There still needs to be notice to the owners that a meeting's happening. And the minutes, while they would not necessarily identify anything of a confidential nature that's being discussed, there would be some record that the meeting took place and the discussions that occurred without the privileged details.
Okay, let's go back to our board. Let's go to Benita. This is about Mr. Rembam. Mr. Rembam wrote an article.
He's not here.
Exactly who is allowed in?
I think you got to go to the next one.
Okay. That's also about gated community.
That's the same question.
Yes.
It looks like it's just continuing on the next page.
Same. I think it's all the way down. Okay. We'll have to have Mr. Rimbaum on one day, and maybe he can answer that. Let's go back to our questions now. Chris in Fort Lauderdale, what legal process needs to be completed before an association can collect the rent instead of the owner? Owner is delinquent with assessment.
Well, when an owner is delinquent, the statute does allow the association to contact the tenant and make a demand that rent be paid directly to the association until such time as the delinquency is resolved. The tenant is protected from liability to the landlord for not paying the landlord rent if the tenant pays the rent to the association in accordance with that written demand. And the association is supposed to only collect enough rent to get to the point where the delinquency has been resolved, and then notify the parties to go back to their normal payment of rent to the landlord.
Okay, let's go to Carlo in Miami. If a condo board okays new rules that allow the residents to have a flower pot or two on the common element, are there repercussions if the docs say no material alterations, since pots are removable?
Well, the material alteration provisions on the statute tend to focus on material alterations being made by the association to the common elements, and generally don't apply to small items of personal property such as the flower pots being discussed here. So if the board is allowing owners to put decorations onto the common elements around their unit, in all likelihood, that would not be an issue of a violation of material alteration. It would be more an instance of whether or not the rules prohibit the placement of such things there, and whether or not the board is following its own requirements or that of the governing documents with respect to that, and if it's appropriately or properly being done in the first place. And that's something the board would want to get with its counsel to make sure that if that's the policy it wants to adopt, that it's doing so correctly.
Okay, let's go to Jack in Delray Beach. Our annual elections are coming up and ballots have been mailed, and some ballots might not have been received. Can we still have a legal election?
Yes, the statute doesn't require that the ballots be received in order to have the election. It requires the association to send them out to the addresses that are reflected in the association records for each of the unit owners. Unfortunately, the statutes don't provide a significant amount of time when you have a lot of owners that might be in other parts of the country or in other countries where the mail is a slower issue. But a lot of communities are addressing that through electronic means of notices of meetings. Now, for elections, it's a little more complicated to do electronic because you have to do the envelope in envelope. So there are online elections that are also being done as an option to allow for more participation of the unit owners in that respect. But for those who are going the old school with mailing of the package and then mail it back and get it to us on time, that's the law doesn't really provide much relief at this time when the mail is slow and people are disenfranchised because of it.
Okay, here's Julie in Palm Beach. Similar question. Our annual elections are next week, but one of our board members passed away. How will this affect the election process?
Well, assuming that there's more candidates than there are seats that are available and an actual election is going to take place, then the first issue to determine is whether or not the deceased candidate won the election or not. As the question is phrased, I'm going to guess that that individual would be one of the winners of the election. So what that would mean from a legal perspective is that there's now a vacancy on the board because the person who was elected is unable to serve. It does not mean that the next highest vote getter automatically steps up and is elected. It means that what most governing documents provide, when there's a vacancy on the board, remaining board members vote to appoint to fill the vacancy. So in that instance, those board members elected that night would have the opportunity at their discretion as to when to appoint to fill the vacancy. They can appoint the person who was next highest, but they don't have to.
Okay, let's go back to our board. Bruce, can a 3-member ARC or CEC committee still meet if only 2 members are available?
Well, a simple answer is yes, that if you have 3 members, 2 constitutes a quorum, so they could meet and they could take all the action that they otherwise could if all 3 were there. Interestingly, as the law has been applied in the courts, if they start with 2 and one of them has to leave and the meeting is not adjourned, the remaining individual, although a quorum is no longer there, can continue to do the business of the committee. So in that instance, I suggest they make sure that things are adjourned before they leave rather than leave things open unless that's the intent.
Okay, let's go to Robert in Hollywood. We haven't had a pet question in a long time. The association allows a pet under 15 pounds. Guests cannot bring a pet to visit. Can we allow a guest a one-day pass, even with an emotional service animal?
Well, if the community prohibits pets and including owners, emotional support animals or service animals are not considered pets, so they would not be subject to that rule, and the association would have to allow them entry. The association should have rules in place on how those service animals are to be handled on the property that is within the scope of what the fair housing laws allow for on such restrictions. But the association cannot prohibit a visitor from bringing a service animal if it's a qualified situation. Now, determining whether it's qualified or not is the difficulty when you're dealing with a guest that's only there for a day, because the board's not in a position to really do the investigation that it's entitled to do to get the qualification information from the medical provider of the individual who's asking for the accommodation. In those instances, it's advisable to err on the side of caution and allow it to visit rather than prohibit the animal and risk a discrimination claim being brought against the association under those facts. That would just end up costing the association more money than they'd want to have to spend on something like that.
Well, we've come to another end of today's show. Great responses, Robert. And Robert will be with us again next month, first Thursday of the month at 5 o'clock, from 5 to about 5:50. Let's give everybody the website, which is very important, and your phone number.
Now you can reach us at 800-974-0680. Website is kbrlegal.com. You can write to us at info@kbrlegal.com, and we'll do what we can to help you.
Well, great show, Robert, again, and we will see you next month, and we'll see you all next week with more Ask the Experts. Thank you, Robert.
Thank you.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.